This is Colin O'Keefe here for LXBN TV. The ignition switch lawsuits against General Motors stand as one of the biggest product liability stories in recent years. But is it possible, due to bankruptcy proceedings, that GM might escape some or all liability? Joining me to discuss is attorney Ben Fader of Kelley Drye Warren, an author on the firm's blog, Bankruptcy Law Insights. Ben, you raised the question in your own piece, and here now, let's jump right into it. Is General Motors potentially shielded from liability here thanks to their bankruptcy? What's your early take on this?
Thanks, Colin. It's very possible that the bankruptcy that General Motors went through in 2009, in which an old entity, General Motors, sold all of its assets to a new entity, which we'll refer to as New GM, and took over that business. And the New GM entity bought those assets free and clear of almost all the liabilities of old GM. Now, what we have going on here is a clash between two very fundamental principles. On the one hand, you have bankruptcy, the idea that companies are allowed to use the bankruptcy code to shed their liabilities, maximize their value, and most importantly, in many instances, as happened here, sell their assets free and clear of their liabilities to new purchasers. Among other things, it saves thousands of jobs. But you also have another very fundamental principle, which is due process, the idea that people are entitled to notice of proceedings that will affect their rights. And the claim here by the plaintiffs in these ignition switch cases are that they did not receive the notice in 2009 of the sale in which the assets were transferred free and clear. And they are saying that there was enough knowledge on the part of GM at that time that they should have been given that notice and they should have had a chance to appear. So what's going on now, and there was a hearing last month, as you are aware, in which Judge Robert Gerber, who oversaw the GM case back in 2009, was hearing these arguments as to whether the sale order that transferred these assets free and clear should be allowed that New GM should be allowed to use the sale order as a shield against these lawsuits that are taking place today. And that's the nub of what's going on.
I see. And then second, let's say, that is the case, and it sounds like they're going to be shielded from a good chunk of liability with regards to these things. What's the remedy for the plaintiffs in the suits filed against General Motors? I understand that there's extra things for people who suffered serious injury and death and that type of thing. But what's the liability for those instances, and then also for the other instances as well? What can the plaintiffs do here?
Yeah, I don't think the plaintiffs are going to be completely shut out. My take from the hearing is that Judge Gerber was very concerned that there was overreaching on both sides' parts. On the one hand, GM's arguments were basically that there was no need to have given notice back in 2009. These claims it was not reasonably foreseeable that these claims existed. But they say even if there was a duty to have given notice, that the remedy should not be that these plaintiffs now get put in what in effect would be a better position by virtue of being able to go after New GM, whereas all of the other claimants against old GM, including a number of claimants who had virtually identical claims based on other defects that were known at that time, who raised the virtually same arguments. And Judge Gerber rejected them at that time. And I think the argument resonated with him that ignition switch plaintiffs are not going to be put in a better position than all of the other plaintiffs who had claims at that time and had to settle for whatever assets were left with old GM. At the same time, I think he was also very concerned with New GM, with what he saw as overreaching by New GM, because there are certain claims that aren't solely attributable to the actions of old GM. And those are claims, in effect, that New GM at some point did gain knowledge of this ignition switch defect, and for whatever reason, it sat on this knowledge. It did not act in accordance with applicable federal laws and federal guidelines, to institute recalls, to notify consumers. And I think Judge Gerber was very concerned that New GM is trying to read this the sale order a little too broadly. So he was, as I said, he was concerned about overreaching on both sides' parts. I think at the end of the day, the plaintiffs will be allowed to bring certain claims that they can show are attributable solely to conduct by New GM after it acquired the old GM assets. But I think that it will be a much narrower subset of claims than the ones that the ignition switch plaintiffs have brought in these lawsuits. And so I think they will get some remedy, some ability to go after New GM, but New GM will be able to use the 2009 order as a shield to protect themselves against a significant portion of the claims.
Well, we've got, potentially a little bit of overreach on both sides, and of course, that's what the judiciary is there for, to kind of split the difference down the middle and see what goes where. So this is going to be an interesting situation to watch, of course, and we'll be sure to stay on track with your publication. Once again, that's Ben Fader of Kelley Drye Warren. For more of his insight on this story and others in the bankruptcy law space, be sure to visit bankruptcylawinsights.com. Thank you for joining me today, Ben.
Thank you, Colin.